federal government's announced changes to the Fair Work Act, which largely follow the recommendations of the Fair Work Review Panel, which was actually undertaken by the previous government. The first part of the changes relate to the individual flexibility agreements that are a mechanism that has been available since 2009 when the Act was introduced. Basically, they are individual agreements that employers and employees can enter into in order to meet their genuine needs. Unlike AWAs under the Work Choices legislation, they can't be a condition of employment, and employees can't be required to sign those agreements. So in essence, these changes now refine or extend or provide some further flexibility around those IFAs, and substantively the changes are that there can be unilateral termination with 13 weeks notice. There's a defence for employers in circumstances where they believe that they genuinely complied with the flexibility term, but it turns out they haven't. Non-monetary benefits can be considered, and what the mechanism that's being put in place, or that's proposed to be put in place, is that an employee sign a genuine needs statement to demonstrate how that non-monetary benefit meets their genuine needs. And finally, under enterprise agreements, there's a model there's a model flexibility term that can be included, and likewise in awards, that's the mechanism by which these IFAs are developed. Up until now, the enterprise agreement could offer less flexibility than the award provision. So essentially, allowances, overtime rates, annual leave loading, penalty rates, and arrangements by which work were performed are the matters that you can have an individual flexibility arrangement in relation to. Enterprise agreements could not have all of those within the agreement, and now they're required to, and any other matter that the parties agree to.
Fay, there are also some changes regarding parental leave and annual leave. Can you talk us through those?
Sure. The parental leave changes relate to the extended parental leave period that employees can request after 12 months. The very simple changes basically that the employer is required to meet with the employee to discuss those changes in an effort to preserve their employment. They still can refuse the request on reasonable business ground, but it's just a procedural requirement that they have a meeting, and if a face-to-face meeting is impractical, then they can actually have a phone conference. The annual leave changes essentially are in relation to accrual of annual leave or taking annual leave whilst an employee is on workers' comp, which will now not be the case. And finally, in relation to annual leave loading being payable on termination, that will only be the case if it's permitted in an enterprise agreement or a modern award, and really that overrides a recent Fair Work Ombudsman determination, which caused a bit of confusion and uproar.
Whilst in opposition, the government indicated it would overturn the recent amendments to union rights of entry. Have they done it?
Well, they're proposing to, and that's, I think, the highly contentious aspect of these proposals. The provisions that say that unions can meet in meal rooms are proposed to be overturned, and it will revert back to that the employer can make a reasonable room available for the employees to hold discussions, and obviously they can't inhibit those discussions, but they don't want them in meal rooms, or the proposal is for that there not be in meal rooms such as not to interrupt employees during their meal breaks. And the second one was in relation to transport and accommodation to remote sites. They're proposing to repeal that, and that actually didn't come through the Fair Work Panel's recommendations. That was a change that was initiated by the government. There's been some further changes proposed in relation to unions and when they can attend on site. Under the Fair Work Act, the requirement was whether they were capable of representing employees. Now the proposal is that they need to be covered by an enterprise agreement, or they need to be invited on site by an employee, and an employee can make and basically go to the Commission for an invitation or some sort of a certificate anonymously, which invites the union to attend those premises. The Fair Work Commission will also have increased power to look at when the union has been excessively visiting a site, and finally they will need to give notice of entry and required to have photo ID when they enter the site for privacy and security reasons.
And what are the changes proposed to Greenfield's agreements?
So the changes relate to single enterprise greenfield agreements, and essentially they put in a 3-month negotiation period after which either party can go approach the Commission for orders, and essentially the Commission will need to be satisfied that the agreement is better off overall and that it also complies with prevailing industry standards.
And have there been any changes in relation to processes in the Fair Work Commission?
Yes, the processes in relation to unfair dismissal applications, actually to date, if an application was frivolous, vexatious, brought without reasonable justification, an applicant failed to attend conferences or comply with orders, they're matters that you can make a submission to the Commission to have the matter struck out. Up until now, employers were forced to attend for a conference and required to often have representation to make those arguments. Basically, these changes will be such that these decisions can be made on the papers without requirement to attend at the Commission, and hopefully reduce the cost and burden for employers, which is often, as a matter of practicality, unrecoverable, particularly from unrepresented applicants.
And just finally, Fay, when are these changes likely to become law?
Well, the ALP and Greens are expected to oppose the changes, which means that if they come through, it's likely to be for the new financial year, so say around July 2014.
Fay, thanks so much for joining us.
Thank you very much, Kate.